So, let's see. Greetings and welcome to the 8th annual Genocide Awareness Day at San Jacinto College North Campus. Before we get started with the program, I want to let everyone know that if you have a question, please use the Q&A section within Zoom to post your question, and we'll get through as many as we can as time permits. Now, April has been chosen as Genocide Awareness Month due to its significance April has in previous episodes of genocide. For example, the 100th day Rwandan genocide was sparked on April 7th, 1994, which claimed an estimated 800,000 to 1 million Tutsis and moderate Hutu lives. On April 11th, 1933, the Nazis issued a decree requiring civil servants who acquired their positions after August 1st, 1914, to prove their Aryan ancestry. And in April 24th, 1915, marks the beginning of the Armenian genocide, where an estimated 1.2 million Armenians were murdered by the Ottoman Empire, now today known as Turkey. This is just to name 3. So this event is organized to raise awareness about genocide, educate the public on the importance of genocide education, and to remember those who lost their lives in genocide. Therefore, today, we do not forget the Armenian victims. Today, we honor the never again cry of the Holocaust. Today, we remember the victims of all genocide. I want to take a brief moment to cover the origins of this term genocide, because it did not exist until 1944. In the aftermath of the 1915 Armenian genocide, Raphael Lemkin struggled with the question why the killing of 1 million is a lesser of a crime than killing a single individual. Being a jurist and an expert in international law, Lemkin coined the term genocide in his 1944 book, The Access Rule in Occupied Europe, Laws of Occupation, Analysis of Government, Proposals for Redress, to capture the totality and barbarity that we as humans are capable of committing against one another. Genocide is a combination of Greek and Latin. Genos means group or race or tribe, and side is Latin for killing. So in short, the term was developed to assist our understanding of the atrocities and the barbarity that the Armenians experienced. Later, Lemkin applied this term to describe the atrocities committed by the Nazis in World War II. Lemkin was successful to add genocide as a part of the crimes levied against the Nazis during the 1945-1949 Nuremberg trials. Here, at the conclusion of World War II, in 1945, President Truman appointed Robert H. Jackson, an associate justice serving on the Supreme Court of the United States, to serve as the U.S. representative and chief of the council to prepare an international military tribunal to prosecute the European Axis powers and their agents on charges of atrocities and war crimes. Once Justice Jackson was appointed, Lemkin sent a letter to the justice that contained 2 key critical components. The first was, it contained an issue from the April 1945 magazine of it contained the April 1945 issue of the Free World magazine that published Raphael Lemkin's article, Genocide, a Modern Crime, and brought to his attention, Raphael Lemkin's book that he wrote in 1944, where he did coin this term genocide. Through his efforts and working with Justice Jackson's team, Lemkin was able to get the word genocide included in the indictment against Nazi leadership. The significance of the Nuremberg trials cannot be overstated. The establishment of legal precedents, the accountability of leaders, the promotion of human rights, the impact on international relations, and the educational and historical legacy. The Nuremberg trials were pivotal in establishing international legal precedents in defining and prosecuting war crimes, crimes against peace, crimes against humanity. This helped pave the way for the development of international criminal law. For the first time in history, major political and military leaders were held personally accountable for their actions during wartime, establishing a principle that individuals, not just states, can be liable for heinous acts, heinous violations of humanity and of international law. These trials at Nuremberg emphasize the importance of human rights and the personal dignity of all individuals, including the creation of international human rights instruments such as the Universal Declaration of Human Rights of 1948. The trial set a standard for the conduct of nations in the international arena, highlighting the need for a lawful behavior in both war and in times of peace. They also demonstrated the potential of international cooperation in the judicial processes. The Nuremberg trials provided a comprehensive historical record of Nazi atrocities and were instrumental in the process of denazification of Germany. And they continue to serve as a profound lesson on the consequences of totalitarianism and of war. But Lemkin's work, however, did not end here. Lemkin's work continued as he pushed the United Nations to adopt the Convention on the Prevention and Punishment of the Crime of Genocide, which is considered international law regarding genocide, and it often provides the standard definition that scholars use when we study this phenomenon. The 1946 original draft included political and other groups. However, resistance from the Soviet Union, today known as Russia, and its allies pursued efforts to actually get this provision removed, to get political groups removed. The reason why is they feared accusations of genocide, which they placed, so they placed this pressure to get this removed, to get these political and other groups removed. We have to recall that there are 5 permanent members of the UN: China, France, the Soviet Union, today is known again as Russia, the United Kingdom, and the United States. So they were able to actually be successful in the efforts to get this portion removed. So Article 2 of the UN Convention on the Crime and Punishment of Genocide. A genocide means any of the following acts committed with the intent to destroy in whole or in part a national, ethnical, racial, or religious group. Please note that the 5 acts include killing members of the group, causing serious bodily or mental harm to members of the group, deliberately inflicting on the group's conditions of life calculated to bring about its physical destruction in whole or in part, imposing measures intended to prevent births within the group, and forcefully transferring children of the group to another group. We should note that you do not have to do all 5 acts that constitute genocide, just one of these. So with that said, I am honored to introduce our main speaker today, Lydia Tiede. She is a professor at the Department of Political Science. She's a professor in the Department of Political Science at the University of Houston, where I'm currently a student at, pursuing my PhD. Her current research focuses on studying high courts comparatively, predominantly in Latin America and in Europe, as well as comparative research on the rule of law and democratic backsliding in developing countries. She has a book, Judicial Vetoes, Decision-Making in Mixed Selection Constitutional Courts, which was published by Cambridge University Press in 2022. Congratulations, Lydia, on that. And she's also she co-founded the community response algorithms for social accountability. Lydia, I am so thankful to have you here, and I'm really looking forward to your presentation today.
Wonderful. First of all, thank you so much to Professor Patterson and San Jacinto College. I think this is a wonderful effort, and I hope more schools and colleges are doing this. I think it's something very important. So I really commend you and thank you for inviting me. I would love to use slides. Should I upload those on the share screen, or?
What you can do, you have the access to actually share.
Okay,
share your
perfect.
screen, so
yeah,
you should be able to do that.
Okay, I think it says you have to stop sharing and then I can share. Perfect. Let's see. Let's see. Does that, whoops. Can you see this okay? Is that showing up?
Yes.
Okay, perfect. Great. And again, my talk, it's limited to, so I teach international human rights as well and have an interest in courts. And so this is really focusing on international courts, a little bit about universal jurisdiction, and a slight mention of domestic court prosecutions. And then weaving in with all this genocide, which has already been discussed. So some of this I won't cover again because it was already done so well. All right, so the big issue is after these horrible atrocities, what do we do, right? With these, excuse me, what do we do with these human rights perpetrators, right? Because a lot of the discussion for Nuremberg, there was talk about, do we really even need to have trials? Right? They could have actually taken the people out and shot them, right? That was something that could have been done and had been considered by the Allies. But no, it was super important to have these trials for many different reasons. One of the reasons, obviously, is to have some kind of retribution, some type of punishment. It helps the victims and so forth. But one of the most incredible things that these trials do is they provide us with a record. So Nuremberg had just tons and tons of evidence, and that's all on record. And the other international courts, which I'm going to be discussing, also have these records. So students and other researchers can actually look at court documents. They can see actually what was done firsthand, as well as seeing, nowadays you can even see testimony on these events. So what is transitional justice? This is a big issue of what do we do after these atrocities? So I have this definition that's kind of a pat definition that's in the, a lot of research or academic, people with academic expertise. Transitional justice is a process of helping societies deal with difficult questions of justice that arise as a society moves from war to peace, or from a repressive or authoritarian regime to democracy. It focuses on social, political, and economic institutions and on addressing past wrongs and on roles for former combatants. As you know, as you go from these horrible atrocities to hopefully peace, there's a lot of issues with reestablishing trust in courts, reestablishing trust in government, and dealing with what happened in the past. This can be extremely tricky because oftentimes a lot of the governments that are, after peace may have been the ones that were involved with some of the atrocities. So oftentimes we see a delay, unfortunately, in things happening. And so some of the issues that I'm interested in, and I think is pertinent for today, is the link of transitional justice methods to human rights. Okay, so again, these transitional justice mechanisms, again, I'm only going to focus on one, which is on courts and trials, but what they're dealing with are explicitly with human rights violations. After war, there's all kinds of other types of things that have happened that are horrible. But these tribunals and transitional justice mechanisms in general are really trying to deal with the worst of the worst human rights violations. They try to promote accountability, and over time, the United Nations has actually sanctioned these methods as a viable means of resolving issues after conflict ends. So we have a lot of purposes for transitional justice frameworks. These are not mutually exclusive, right? So you can decide, a country can decide that they want to have all these different types of justice. But just as a sort of short reminder of what these are, you have restorative justice, which is really just trying to restore individuals to where they are and to get the truth out. Okay, so here you usually see truth commissions. With these, there's no penalty phase. And oftentimes perpetrators are offered some kind of amnesty or a lower sentence if they tell the truth. Okay, so they can have again, these also set a historical record. Because there is no penalty involved in them, they might get people, perpetrators, human rights violators, to come out and tell us what happened. You know, unfortunately, where are the bodies? What was actually done? So this gives us a good record. Retributive justice is one which is more punitive. This is where individuals are actually being held accountable for crimes in these international or domestic trials. One of the issues here is that this does not necessarily foster truthfulness, because you've got someone on trial and they don't want to be found guilty. So they're not going to tell you where the bodies are, what actually happened, because they're fighting for their own benefit, for their own interests. So again, it has a punitive nature. It is very helpful to victims. It does provide a record, but it's very different than just a straight out truth commission. And then we have other methods, this reparative justice, apologies, and reparations. So as I mentioned before, I'm really going to focus on courts and international tribunals and even domestic tribunals. And this is retributive justice, right? And again, the justification is acknowledgement of wrongdoing, punishment of a human rights violator. It serves an educational purpose, right? We can all watch this, we can read about it. It may provide deterrence, at least of the individual human rights perpetrator, who is hopefully will be prosecuted and locked up. Whether it has a more general deterrence of having, you know, if other leaders see that somebody has been brought, had, I don't know, genocide charges against them and is going to serve a lengthy sentence. I think the jury's still out on that, whether that deters another probably crazy person from doing this in the future. But it has the potential of having a deterrent effect. I think that's something we're going to wait and see. And it shows society that justice institutions actually work. So either international tribunals or oftentimes countries themselves hold trials, right? So we saw this in Germany. So we had the Nuremberg trials for these big crimes involved with what the Nazis did, but then there were a lot of other trials that happened within the German judiciary. Okay. So again, two types. You have these individual domestic courts. So Germany can and has and still does, believe it or not, they still have defendants that are, you know, in their 90s that they're prosecuting, right? So they can actually still prosecute within their courts. And this is a nice method when, you know, sometimes the money runs out on the international tribunals, or they're not prosecuting enough of the lower level individuals or enough of even the higher ranked individuals. So the domestic tribunals do provide, you know, sort of another outlet. And then we have international war crime tribunals, which is what I'm going to talk about mostly today. Some of these are ad hoc. They were set up specifically for a crisis. So there is something, you know, we have the Yugoslav war, we have the situation in Rwanda, right? We have Sierra Leone, other issues, and the UN will set up an ad hoc tribunal, international criminal tribunal that will deal only with that crisis. Over time, that is seen to be somewhat inefficient. So there was the creation of the International Criminal Court, which I'll get to later, which now covers, we don't have to constantly be setting up new tribunals when these horrible things occur. So one thing I want to mention is universal jurisdiction, and this is important for us to understand in both the limitations of the International Criminal Court, but also as another way for domestic courts to get involved. So what could occur is that rather than the country where the human rights violations occurred, rather than them actually prosecuting these cases, there is this possibility under universal jurisdiction for a country that is completely not involved in the war, doesn't have any citizens involved in the war, but some of these human rights perpetrators end up in their country, right? So we had Rwandan individuals who committed genocide from Rwanda in Belgium and in the US. And the US and Belgium courts, and Canada, I believe as well, were able to actually prosecute those individuals under this universal jurisdiction. So it's very rare that it's used, but just to be aware of it. Okay, so it wasn't used very much in the 1990s, but then, you know, we did see these individuals trying to escape, right? A lot of these individuals that committed genocide from Rwanda were traveling, right? And so the courts actually got hold of them. And the idea on this is you're thinking, well, what's the link? Why would the US get to even try these individuals in US courts? And the idea here is that the crime is so heinous that it affects us all, and we all have a stake in this. So it doesn't matter that the US is not directly connected, doesn't have US citizens over in Rwanda or former Yugoslavia. It's the fact that the crime hurts all of us. It hurts humanity. It hurts every citizen in the world. And that allows them to get hold and actually charge and prosecute these individuals in those courts. So just to kind of to be aware of, and we have these cases in Belgium, Chad. So the leader of Chad was actually prosecuted in Senegal under the universal jurisdiction. Pinochet, we had some issues with him, but as far as him getting sent back to Chile, we have these Rwandan cases. I have Canada, France, Switzerland, and also the US did prosecute them under this principle. All right. So I want to kind of go through some of these tribunals. It's a little bit fast and furious. I think you could have, you know, a course on probably every one of these. I think, as Professor Patterson knows, right, this is something, you know, you could spend lots and lots of time. So again, we had the, you know, the two big ones, you know, right after World War II are the Nuremberg trials and the Tokyo trials. So you don't hear as much about the Tokyo trials, and I'm not going to really cover those. I don't have as much of an expertise on those. But you did have the Nuremberg trials, which we've discussed. And these were created under the London Charter of the International Military Tribunal. And this was a charter that was created to say, what is the court going to do? What is its jurisdiction, and what are the actual crimes, right, that we can convict these individuals for? Because the problem was, at this point, this is kind of the very beginning of international law dealing with criminal responsibility. And so there weren't laws, there weren't crimes written down for these things. So they actually needed to have a document to tell the court what is its jurisdiction, what charges can be brought against these individuals, and what types of cases can the court hear. So again, it was somewhat limited at this stage. It only had a few crimes. So it had this crimes against peace. So this was the namely planning, preparation, initiation, or waging of a war of aggression against international treaties. It also had war crimes, right? These are violations of the laws or customs of war. They include things like murder, ill treatment, deportation to slave labor, you know, all these types of things, ill treatment of prisoners of war, wanton destruction of cities, and these types of issues, right? And these are actually very much spoken in customary international law. So again, it is put in a document here so the court in Nuremberg knows what to do and what they can address. But that actually, a lot of this comes from international law or customary international law. And then we have crimes against humanity: murder, extermination, enslavement, deportation, and other inhumane acts committed against any civilian population before or during war, persecutions on political, racial, or religious grounds. The court also had jurisdiction over these. All right, so again, they also had, besides those 3 specific crimes, also anyone that was involved in any type of conspiracy or was helping with these crimes, they could also be prosecuted under this London Charter. Now, at this point, even though Lemkin was out there and he had brought this, he lobbied the US like crazy and the United Nations to get this idea of genocide down there, it actually wasn't listed. I think the word was mentioned and he was actually sitting in the trial, in the trials, but it wasn't actually listed as a specific crime for Nuremberg. So no one was prosecuted specifically for genocide. The charter didn't actually, we didn't have enough states ratifying it, so it didn't come into force until 1948. At that time, we do have the Genocide Convention. Many countries signed on, and as Professor Patterson stated, we have this now definition of what genocide is. And this is great, right? Because now when we see it, it can be put into other charters. It can be listed as a crime. It can be anybody that signed on this treaty can be prosecuted if they commit genocide. And better yet, it's also a jus cogens norm, which means even if you didn't sign on to the Genocide Convention, but you commit this, you can also be prosecuted. So again, this was, as already mentioned, this is, a turning point. We have this new crime. So again, what we see is sort of the development, after World War II, we start seeing this, creation of all these different ad hoc tribunals, because unfortunately, even though we said never again war, here we are, right? We have more wars and really horrible things that we continue to see, right? So in the 90s, we have the war in the former Yugoslavia, the breakup of Yugoslavia, and this real necessity to set up a war crimes tribunal to deal with all the horrible things that happened here. And the UN sets this up because at this point, there is no International Criminal Court. There's no Nuremberg tribunal, and the Nuremberg tribunal had a very limited jurisdiction only to cover issues involving the Nazis in World War II. So again, they had to recreate this, and they do the same thing. They create this charter, right? So again, this was, it dealt mostly with these crimes and dealing with the conflict in Bosnia and Croatia, with Serbia. It later was expanded to the crisis in Kosovo. The highest ranking conviction was Ratko Mladic, the commander of the Serb forces, who did receive life. So this was created in 1993, and its work took this long to complete, all the way to 2017. So one thing I think is, and this is from the tribunal websites as they close, as part of our historical record, I think you can take, and I'll show this for each of the courts, I think you can take this in 2 ways. You can say, oh, they did a lot, or, oh, why aren't there more people convicted, right? And so that's something you have to come up with. So they indicted or charged 161 individuals, okay? And again, these international tribunals, Nuremberg, all these ad hoc tribunals, as well as the International Criminal Court, what they're supposed to do is get the highest level perpetrators, right? They're not dealing with the rank and file soldiers. So their purpose is really to get the highest level, which could also indicate why we don't see as many sentences. So again, in this, we have 161 individuals indicted, and 90 are sentenced. So 90 are acquitted. 90 are convicted and sentenced, okay? So for some, that's not a lot. For others, it is. The crimes as listed here, we have genocide, right? That is a listed crime. Crimes against humanity, violations of law, customs of war, grave breaches of the Geneva Conventions. So again, we've moved away from Nuremberg, and now genocide is actually a crime that's listed. And as you see, what else is quite interesting is you have all these witnesses, 10,800 trial days, and 2.5 million pages of transcripts. So that is the record. So this is one thing, as I mentioned before, that comes out of this that is very positive for researchers, for people that want to understand, right, which you're trying to do today and participating in this, right, is now we have some documents we can read and learn more about this. We also have the Tribunal for Rwanda, right? So this is set up 94, lasts to 2015. And again, these are established by the UN. Again, this one is interesting. Well, actually, both the Yugoslav Tribunal that was held in The Hague, so outside the country, Rwanda as well. These cases were heard in Tanzania. Okay, so again, they tried to move them out of the countries because of the politics and emotion involved with these. So again, this is fairly similar to the Yugoslav Tribunal. We've got 93 individuals indicted, so maybe not quite as many as the Yugoslav Tribunal, and 62 sentenced. Okay, and some are acquitted. And again, maybe, you know, I don't think this is a failure. They have evidentiary rules. They have to prove their case. And for legitimacy purposes, we don't want them prosecuting individuals that they don't have evidence against, right? That would be wrong. So it's very, you know, sort of law and order process. It has a legitimizing effect on what is being done. It has credibility because they're not just sentencing everybody that appears before them. They're actually carefully going through this and using judicial process. The other thing that happened is that after those two tribunals closed, they still had to deal with the fact that there were some residual cases and some other issues, individuals they didn't get. So they created this international residual mechanism. And this just deals with cleaning up sort of the extra cases and extra indictments that were out there. Now I want to go to the International Criminal Court, because this is really, I think, the legacy of Nuremberg, really, is let's not just keep creating these courts in the hope that we'll never have these things happen. Let's acknowledge the fact that we have these horrible things occurring and have an actual permanent court set up. So again, as I have here, this is the first treaty-based international permanent court with international jurisdiction. It's a criminal court, and it was set up by the Rome Statute. It is limited in certain ways because its jurisdiction, or what it can hear, is very specifically delineated. And I'm just going to go through that to you just briefly, just so you understand the fact that it has very specific things it can do, it can hear, and things it can't. So again, it's limited to the most serious crimes. And this is anything, any type of these, you know, grave international human rights abuses occurring, okay, where individuals are going to be prosecuted criminally. So it deals with crimes of genocide, crimes against humanity, war crimes, and crimes of aggression. So just those four. That seems like plenty. But again, you could have lesser types of crimes, property damage, all these different types of things. Those aren't part of what they do. It has jurisdiction over individuals accused of these crimes, either those directly responsible or other ones that maybe were responding to what their superiors said or did conspiracy. The summary of evidence that the prosecutor presents establishes reasonable grounds to believe that the person committed the crime. If they meet that standard, they can go forward. And again, these international tribunals have sort of a cross-section of common law practices, as we see in the US, but also civil law practices, which are done in continental Europe and other parts of Europe. So it's kind of a mix of those two legal traditions. The court does not have universal jurisdiction, okay? So they can't just sort of grab people willy-nilly, okay? They only have three ways of actually prosecuting individuals. Either the accused is a national of a state party or a state accepting jurisdiction of the court. So the International Criminal Court has a treaty, and all these countries signed on, except, as you know, the US. And so if you signed on to that treaty and you commit genocide, the court has jurisdiction over you. Okay, so that one's easy. Another one is the crime took place on the territory of a party that had also signed on and accepted jurisdiction of the court. So let's say some invading power comes into your country. You're of a country that has signed on to the jurisdiction of the International Criminal Court, but that other country perpetrates genocide in your country, they can also hear the case. And then the final way is the United Nations Security Council can refer cases. So maybe they say, International Criminal Court, we want you to go after, I don't know, Bashar of Syria, right? They can actually tell the court and refer a case to them. So those are the only three ways the court can hear cases. So again, in the situation of the US, only if the UN Security Council refers the US to the ICC could the ICC ever hear a case. But as you know, the US is one of the permanent members of the Security Council and would veto that. Okay, so again, it does have some limitations. Other limitations are it doesn't hear any crimes that occurred before July 1st, 2002. That's because it didn't exist. So they can't go back in time. It can only exist from the time that the treaty was ratified and went into force and forward. So even though there's horrible things that happened in the past, if they were before this 2002 date, it can't be heard by this particular court. Now, domestic courts might be able to, right? So the Germans can still hear their cases against German former Nazis, right? But the ICC couldn't. Okay, the case has to be sufficient gravity. And then this other proviso, even when the court has jurisdiction, it will not necessarily act. The principle of complementarium, if it's thought that the state itself could handle the cases, then those could be heard. So this was the big issue in Colombia, right? We have the Colombian peace accords, right? And those cases could have gone to the ICC to prosecute members of the FARC and others involved in human rights violations. But Colombia wants to keep those prosecutions in its country, and it sets up an entire elaborate peace process. I actually got to go visit that court, I guess about a year ago, right? And so they actually made it so that they could hear the case and the ICC did not. It was quite debated, but the ICC relinquished its control over those. So again, 7 countries vetoed or are not members of this. And there may be more that are getting out of it. And then the other thing to realize is besides this ICC, there are still some of these other types of ad hoc tribunals going on, right? I have a few listed here just to be aware of. I think the Sierra Leone special court is probably one of the best ones as far as reputation and what it got done. They were helped quite a bit by the British as well. And so some of the success and challenges, just to finish up. So again, it creates really rich jurisdiction. We're having case law now that defines what is ethnic cleansing, right? That might be something that's lesser than genocide. What's required to, let's have actual facts and case and law on all the requirements of genocide, right? Just because it's written down in the statute doesn't mean there's not other legal issues, right? So they create this case law that helps us in the future deal with these different issues. And even issues of process, right? So now we have this rich jurisprudence. They also have things, so a lot of times some of our treaties don't deal with sexual abuse during war. These tribunals have actually litigated cases and talked about how these extreme cases of rape as a tool of war are war crimes, right? And now we have that in a case. So that can then be used in other international and domestic cases. We define genocide, other war crimes. So these are all great things. Challenges, again, as I mentioned, it's uncertain if it's a general deterrent effect on other would-be human rights perpetrators. We don't know if it stops them. It's hard to arrest suspects. So a lot of these individuals, some of the courts have to actually have physical control of them. They can't be tried in absentia. So sometimes it's hard to get these individuals. Some countries are now withdrawn. And in the case of the ICC, we have this sort of uneven focus on African countries. So there's been seen to be some bias. And then there is some debate recently, maybe 2 years ago, the economists had some argument about genocide itself, whether calling something genocide, unfortunately, is actually making it possible that courts and even countries don't react. Because if you call something a genocide, it means that you do have to get involved. The US has, anyone that's joined the Genocide Convention, they actually have a legal obligation to get involved. So now countries are quite hesitant to call something genocide. So unfortunately, it may have had, there is some argument that by creating this other category, even though it is useful to understand what it is and to be able to see it, that perhaps by naming it, it has actually made countries claim a lot of things that we know are genocide as not genocide, so they don't have to get involved. So thank you very much, and I welcome any questions.
Awesome. Thank you so much, Lydia. Kristen, do you want to do the Q&A? Oh,
Absolutely.
we
So we are running short on time, and I do want to keep it to an hour to be respectful of our audience. And so we can just go straight into the Q&A. That's totally fine. So let's start. We have a question from Jesse, who says, persons who are accused of crimes of genocide and are in the trial process, are they held anywhere? Do they have to stay within their current border while the process is ongoing?
Do you want me to handle that one?
Yeah, I would love for you. This is more your area than mine. I'm a historian, so this is definitely more in your wheel.
Okay. Yeah. So just and I'm sorry if I went over too in the late start on this.
Oh, no worries.
Yeah. No, I think on this one, it's really, so they're either taken to these international tribunals and they have holding cells. So both the former Yugoslavia and, Rwanda, they actually held them there. So they're taken there. Domestically, if they're being tried domestically, those countries are going to make sure that they do stay within their borders. So it just depends. And then on those universal jurisdiction cases where they find somebody from Rwanda or somewhere else that committed genocide, those countries are going to hold those individuals because obviously they have a lot of incentive to flee.
Awesome, thank you. If anybody has questions, we'd love to get them in the Q&A feature. But while we're waiting on any further questions from the audience, Professor Tiede, I would love to get your perspective on, I have sort of two questions, but I'll give you one first. You addressed how the number of people prosecuted versus the amount of time that these trials have taken, certainly the amount of money that they've taken.
Yeah.
In your perspective, do you think these trials are effective, whether that means just prosecuting the people who are involved, or that could, I suppose, be broader in terms of what it says internationally, deterrence? I'd be really curious to hear your perspective on that.
Yeah, I mean, I do actually, I'm probably a true believer, right? So I actually do think they were effective, but I think they were met with a lot of reticence. So I was lucky enough in the before the Rome Statute was created, there was a lot of discussion. We had a war crimes czar, you may remember, back in the 2000s, and they had all these talks. And I went to Los Angeles where he was speaking, and there was so much resistance from the U.S. to get involved, as well as other countries. So a lot of it was that these countries want to kind of control. It's mostly about their own soldiers. They don't want them being brought up. It's again, this constant issue of sovereignty, right? People don't want to have others saying who's doing wrong or not. As far as effectiveness, I think it's how you define it. So I think they did have some high level convictions, right? Unfortunately, with the Yugoslav one, you've got like Milosevic, the highest one, and then he dies, right? So that's kind of, we don't get there. Same with Pinochet. Again, that was done within Chile, right? He's first found unfit and then dies. So you never get these final convictions. So that part is very upsetting because, and originally in Guatemala also, we have some issues where they don't go go the whole way. So that is an issue for effectiveness if they can't finish these. So I think they need to move these things around quicker. The money is huge. I do think it's an important record for us and for individuals, and also to call something wrong, because you can't, if you just, we do see, I think I'm teaching it for the very first time, international law and law of war right now. And it's so frustrating because we do have laws and we have courts and all this, but it's all, it's inconsistent how it's applied, right? So you see horrible things happening in Syria and not much action, right, from the international community. Whereas, you did see, and then even Yugoslavia and Rwanda, right? So we get involved more in Yugoslavia than Rwanda. But as far as effectiveness, I think having, it is good for the victims. It is good for the record. It's good to have the conviction. So I think those are effective. But I think it's too slow. It's probably too costly. The idea of having the permanent court was so that we don't have to spend all the money resetting these things up, and we've got processes in place. I think it gives legitimacy to it. I think they do have to get rid of any perceptions of bias, though. And then obviously not having the US signed on to the ICC does hurt its effectiveness. It does undermine it to some extent.
We got a really great question, Stacy. This is more of a philosophical opinion question that I certainly have on, but I'd love to hear your opinions too.
No, I'll have you deal with that. I'm not
so she says, even though some of the soldiers were 18, do you believe they should still be prosecuted, since there might be some that were scared and were threatened themselves to do these acts? And that is, Stacy, that's the big question, isn't it? So from a historical perspective, when you're looking at Nazi Germany, when you're looking at Yugoslavia is a great example of this too, right? A lot of this stuff is being directed from the top. And so who do you then prosecute? And Cambodia as well, right? Who do you prosecute, and where's the line? And is the defense of I was just following orders, is that sufficient to protect somebody from? And I think what we kind of see is that this is why the courts really try to go after the higher level offenders first. And they really try to go for the people that were directing things, the people who were either passing those orders to people underneath them, or people who had some kind of clear, very specific involvement. For example, the commandants of concentration camps in World War II. And so personally, I am sympathetic. I don't think the I was just following orders is enough of a defense for me. However, I do understand people who are those lower level sort of foot soldiers. You can never prosecute just from a logistical standpoint. And I also think that there's probably not as much benefit to prosecuting those people, but yeah, that line is really, really hard. And that's why we still have, people who are involved in the Nazi Party getting prosecuted in their 90s. And so, yeah, it gets really, really sticky. Professor Tiede, do you have a perspective on that?
No, again, yeah, it's very hard, and I know, I get another historic example would be the My Lai massacre, right, in Vietnam. So this was an issue, and that was prosecuted more under the Universal Code of, or the Code of Military Justice for the U.S., right? But yeah, there is a big problem getting these individuals. I think on this issue of the age also maybe provide something, because as you know, we have international law that says that child soldiers, can't be involved in war, so 15 and under. But international human rights law and the Convention for the Rights of Children put that at 18. So there's this kind of conflict of whether these people, should be responsible. So I think the question also sort of speaks to this sort of age. And there's one thing for soldiers rank and file, should they know the difference? Should they be prosecuted? It's another thing for, I guess, these individuals that are 18 that are sort of drawn into this war.
Absolutely.
If I could chime in just very quickly.
Go ahead. Yeah, please.
About this age of 18, I would definitely say that they should be held accountable. To what extent? That's the question. If you're at the age of 18, right, that means you are legally classified as an adult. So you should face accountability. You should face consequences. To what severity should that punishment be? Will all come down to context, come down to what they actually did, and were they forced to? What I mean by forced, physically threatened, et cetera, et cetera. So there are some circumstances there, but should they face accountability? Yes.
And also, just once again, speaking from this is from an American history perspective, but the accountability can look like different things. Does accountability mean that you can no longer serve in politics? Does accountability no longer own a firearm? Does accountability mean you serve time? So
We
I think
we
it
may have
froze.
lost Kristen now.
I thought it was me.
No, I don't think so. So this
Okay.
is hopefully maybe Kristen can come back. But in the meantime, in the essence of and to respect the time and everything, let's see. One more thing here. And then I just want to say, if there's anything that we've discussed here that is interesting to you, or that you had a question that we didn't get time to, here's our contact information. Please feel free to reach out to us, and we've been more than willing to carry on this conversation as it is critical to our understanding. So with that said, Lydia, I just want to thank you one more time. I really appreciate your time and your expertise.
no.
This was amazing.
Yeah,
Thank you.
no, I think this should be done across all universities. So I hope I didn't speak too long with
No.
Professor Williams speaking. So but yeah, this is a great initiative. So I commend you.
With that being said, like I said, to respect time, I really appreciate you, Lydia, and our audience as well. Thank you so very much for being here today. Thank you for participating in Genocide Awareness Day. We hope to see everyone. Oh, it looks like Kristen was able to join.
yes, I am so sorry. I'm having internet issues. I'm sorry. I just wanted to conclude with that question because it's really interesting. And so all I was going to say is war. The United States was willing to justify a lot of things, whether it was taking Nazi, scientists and other people involved in the Nazi regime and using them here in the United States, also overthrowing democratically elected leaders across the world. The United States sort of was willing to fudge on its own values a little bit for the practical purposes of the Cold War. And so, yes, I apologize for getting kicked off, but that's sort of the long and short of what I wanted to say.
Well, with that said, Kristen, thank you. I just want to say thank you to everyone. We look forward to seeing everyone again next year for Genocide Awareness Day. Thank you so very much. Y'all have a good one.
Thank you, everybody.